This is the Mobile Home Park Lawyer Podcast with Ferd Neiman. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd Neiman.
Welcome back, Mobile Home Park Nation. Ferd Neiman here again today with another episode of the Mobile Home Park Lawyer Podcast. Got another great guest for you, colleague of mine, lawyer, businessman. Got a lot of interesting stuff to talk about today. Please help me welcome my guest, Doug Raney. Doug, thanks for coming on, man.
Hey, thanks for having me.
You got it. Well, obviously, I know you well, better than most of my guests, but some of our audience probably doesn't. So maybe give us a little bit of your background. You've got an interesting background from school to your first couple jobs to practicing law. So share that with us.
Yeah, so I graduated law school back in 2010 and had some unique opportunities out of law school and ended up spending a lot of my career as a general partner and managing member of real estate development, been involved in oil and gas. So certainly seen my share of contracts from the client side, as opposed to the attorney side, and have been with the firm for almost 2 years now. So tend to take a probably more business oriented approach than most attorneys.
Sure. And then you're a finance math guy too. Tell them what you did before development.
I played poker as my main source of income during law school and kind of the first few years after it, before there was some significant legal changes to online poker that got me out of that shortly after I graduated law school.
Yeah, well, I think it's always interesting because what you do a good job of is assessing risk and probability. Because you can tell you use poker terms that I used to play poker, not the same level, but it's like we can speak the same language, but I know our clients appreciate it. We're like, well, there's a 5% chance this could happen, but the downside result is catastrophic. So you got to really weigh that in versus
Yeah.
it's 50-50, you could do this, but if you've only got a 1% upside, then it's not worth it.
Yeah, without getting too into the weeds on this, I think the biggest takeaway from my experience, kind of as an advantage gambler, as they call it, is kind of weighing probability with the impact of that probability, and that's a term gamblers like to call expected value. I mean, if someone offers you $100,000 or a 10% chance of $1 million, your expected value is the same, but for most people, because of the risk tolerance, they'd much rather have the guaranteed $100,000. Well, let's say you have a $100,000 or a 10% chance of $1.1 million. Well, then might be different depending on each person's risk tolerance. So I think it's kind of important to call that out to the client as much as possible, like what the situation is, and not make any assumptions about the client's risk tolerance. So it's really more about helping clients help themselves more than just telling them this is what you ought to do.
No, I think that's prudent as you look at documents, you look at deals, assessing those things in the EV. Maybe you give that. I didn't prompt you with this, but I'm sure you remember it. You've used the example a few times about the jar of white marbles and black marbles, and pulling one out at random. Can you give that example? I think that's helpful for a lot of our clients to really assess, like, oh yeah, I didn't think about it the same way. It focuses on like the stakes at play at times.
Yeah, so I mean, a lot of times, lawyers are looking out for themselves more than their client. I always advise anyone to consider the agency costs. What are the real incentives of the person who's supposed to be looking out for your interest as opposed to your actual interest? And one thing that lawyers are kind of notorious for is being overly cautious, and they have no problem encouraging you to spend thousands of dollars in legal fees, to avoid a situation that's really a 1 in a million chance of happening. But the attorney, if anything, profits from you spending that additional money. They don't care. If anything, they're happy to see you waste money because they make more, billing hours, and they're not really upfront about the fact it's a risk, but it's a pretty small one. So the example you gave about the jar is, let's say there's 100, ping pong balls in a jar, and maybe 30 of them are red and 70 of them are black. Like let's say you lose, I don't know, $50,000 in litigation costs if the red ball is pulled. Well, 30% is pretty severe, so it's probably worth spending a few $100 to pull one of the black balls. If you have a million balls in the jar and there's like 3 of them that are red, it's probably worth rolling the dice a little bit. So again, I always try to make the client aware of the worst case scenario, but I think it's also in the client's best interest to be upfront about how real do you really think that risk is. So you're not encouraging the client to spend, $1,000 or even $500 addressing a problem that's, 2 or 3 red balls out of a million chance of, actually being a problem for them.
Yeah, good point. I know one thing that my clients really appreciate with me is because I have a business sense, in particular MH operations, is I'll tell them like, here's what I would do. Like I'm your lawyer. Here's the worst case scenario. Here's all the options. But here's what I would do. And it's easy when I don't have a financial incentive. I'm like, look, here's what I would do. I would buy a phase one environmental with every single mobile home park you purchase. And like, and I'm unbiased here because I don't sell phase one environmental. So I'm not getting any money from that. I can even give you referrals. I'm not getting any kickbacks for any fees. I'm just telling you, this is what I would do. This is good risk mitigation. But also, I wouldn't do it the day I went under contract. I would first do other free stuff, run a financial model, talk to investors, talk to the bank, look at the market stats, things like that. So there's a hierarchy, but also a linear priority of diligence items. And some of them are free, some of them take time, which is not free. And some of them you have to pay a third-party vendor like a surveyor, which is not an inexpensive cost. So definitely important to kind of weigh the pros and cons of kind of a cost benefit analysis at all times. So I've got several other episodes on contracts and PSAs in particular and key provisions, but a lot of times we get a contract that it's already been signed or already been wholesaled or assigned to our client that we had no influence on. And then sometimes we have contracts that we did negotiate, but still something comes up where you need a contract amendment. So that's going to be a key focus for today. So maybe tell us, for the lay people out here, what is a contract amendment and why is it necessary? And then we'll go from there.
Yeah. Well, before we kind of have a discussion about it, I'll go and start just by reading the definition. A contract amendment, also known as an addendum, is a document used to modify, add, or delete terms and conditions from an existing contract without entirely rewriting the original agreement. It serves as a formal and legal way to make changes to the contract if after it has been executed by all parties involved. That's just basically another way of saying, you have an existing agreement, something changes, you learn something that you didn't know at the time you signed the contract that makes you want to change the terms of agreement. And there's quite a bit of reasons why that we'll get into, why you might want an amendment, but that's the gist of what an amendment is.
Now, does these have to be written or can I have a verbal amendment?
Always we recommend a written amendment. And in fact, that's kind of something, especially with friends and family, you see as, people try to keep things informal. There will be a bunch of email strings that, people kind of point to. Even worse than the email strings, just a verbal communication. It's like, okay, we've seen the agreement, but we got to address this. We'll just kind of both agree that this really means that. Well, ultimately, if you ever actually have to enforce this agreement, either in court or with an arbitrator, or even a mediator, it's by far the cleanest to everybody just to have a formal amendment that just memorializes exactly what that agreement is, so there's no dispute down the road. And the reason I bring up friends and family is that's, I think, the most common mistake I'll see people make is they think, oh, we're friends, we don't need to be that formal. In my view, it's especially important, not less important, to be formal about agreements with friends and family, because not only do you risk the business relationship, you risk your personal relationship, and that happens all the time. It's
Right.
kind of part of that reason for some people don't recommend even doing business with friends and family, but it happens. And if you're going to do that, everyone can be happy with each other, so on the same page, just put all that in writing.
No, agreed. I think I sometimes will say if it's not in writing, it didn't happen.
Yep.
Because even if two people, if you and I are trying to do a handshake deal and we're both honest, good guys, our memories might be different. And I got a pretty good memory, but my notes are better than anybody's memory because I don't lose them. They're written down. And a contract amendment in writing is crucial. And then just, underlying documents should be in writing also. I think, in law school, they teach us the statute of frauds, which is basically any real estate transaction or any personal property transaction above a certain threshold. I think it was 5,000 last I looked at it. Then that must be in writing in order to be enforceable. So it makes sense to have in writing. Email doesn't count. In theory, you can amend agreements via email, but it's better just to have a simple contract. Maybe it's something 2 sentences, or there's generally a whereas clause, and then here's the parties, here's the date, whereas, now, therefore, and then you have some boilerplate of like they can be executed in counterparts, facsimile or scanned copies acceptable. Excuse me, but generally having the bullets in there in a written document, and then I like to have the title of the amendment reflect the title of the underlying document. So, for example, I'll see somebody say purchase contract, and then later they'll amend it and they'll say amendment to contract. And then later they'll say addendum to purchase agreement. And it's like, okay, well, it's better to say if the real document says purchase and sale contract, and then the amendment should say first amendment to purchase and sale contract. The next one should say second amendment to purchase and sale contract. One of the first assignments I got from one of our biggest clients was they had like 23 extensions and amendments and addenda. And they're like, will you just follow these through and make sure that the current understanding is valid? And I gave it to one of my associates, and they're like, no, we don't mind paying for each of you to do it. Normally they don't want to pay double. And they're like, we want you both to do it. And I got done with it. It was only like 20 minutes. And I look at the associate and I was like, it's pretty clear to me that this is what it is and what it isn't. He's like, agreed. But our client was with so many of poorly drafted different forms, and there was a wholesale in there and another wholesale and a termination and a repurchase, that it became clear as mud. So having it crystal clear is obviously more helpful.
Yep. And I think it's equally important to date each of those. Have as many reference dates as possible. In some cases, you even say, the September 13th, 2023, contract for the purchase and sale of real estate, amended by the October 21st. And the more information you can provide that gives context to a third party, again, either judge, mediator, and even amongst yourselves, as the parties to the contract, the more clear you can be kind of telling the story about what's the timeline for each of these changes, the easier life is going to be for you, if you ever need to resolve a dispute down the road.
Yeah, good point. So let's segue into, some of the reasons why you need an amendment. So you mentioned, clear and having that detail, and obviously that's the way we do it here at our firm, but vagueness is often a problem. So give us an example of when something's vague and why that requires an amendment.
Yeah. So, a lot of it might just be there's a, disagreement on how to interpret things. And even, this isn't an example, but just in general, it happens to the best of us. You can have as good of a contract as you can, want to have, put as much time into it as you can. And ultimately there's something you didn't think of. Like there's two different ways to interpret this. And, even Supreme Court justices disagree on how to interpret certain things. So, you can only do so much to cure a disagreement. But, whether you have something about, well, does the sale include XYZ or does it just include X and Y? Maybe there's some disagreement on whether it's implied that Z is included as well or not. Well, the buyer might say it is, and the seller might say it isn't. Well, you might have an amendment that is a compromise. You'll say, okay, will it not include Z, but I want a reduction in the purchase price. I thought I was getting that when I agreed to $1 million. If I'm not getting Z, it should only be 950,000. And then maybe seller counters, no, I'm not going to knock off 50,000. I'll knock off 25. Okay, great. And so then you just have an amendment that clearly says both parties agree, whereas X, Y, and Z kind of outline the basic facts, the recitals. The substantive, now therefore clause will say the purchase price is hereby reduced to $975,000. The parties further agree that Z, whatever Z might be in the context of the purchase agreement, is not included, with the sale. This, to me, is a good time to mention a more general principle that, especially if you're the buyer, most of our clients, not all, but most of our clients tend to be buyers of, mobile home parks. If you're the buyer in a contract here, the sooner you can flesh out any sort of disagreement like this, the better. Particularly, you want to make sure you have this discussion before the end of your inspection period. Just because once your inspection period ends, typically whatever earnest money is in escrow becomes non-refundable to you, with the exception of some very limited circumstances like seller's breach of contract and so forth. If you have this discussion about, okay, is Z included in the sale? And if not, how much money am I going to get off of the purchase price? You have a lot more leverage to negotiate a favorable amendment, which is really a form of settlement of a dispute. It's a much cheaper form of settlement than going to a mediator, go to arbitrators, kind of an informal discussion. Maybe your attorney's involved, are involved in that discussion, but ultimately you're kind of heading this off the pass and getting ahead of the disputes before it becomes a lot more expensive, your leverage to negotiate a good outcome is much, much higher before the end of that inspection period. Because if the seller isn't willing to play ball, if they're not being reasonable, or even if they are being reasonable, you just can't see eye to eye, no problem. You just terminate the contract, get your earnest money back, you're out, whatever, due diligence costs, legal costs, anything along those lines you've spent, but otherwise you're unscathed. If you wait until after the inspection period, or even worse, until after closing to have a discussion like this, then, well, now all of a sudden you're out either your earnest money or even worse, the entire purchase price at closing. Then you're trying to kind of negotiate a resolution to this dispute with one hand tied behind your back.
Yeah, I mean, good points there. I mean, yeah, just vagueness in general can lead to disagreements or just a lack of agreement on the interpretation. So I think anytime there's a lack of specificity, we should look into it. Anytime there's a gray area, like I had one where I was doing an eviction one time because I had to do it myself because our local attorney was conflicted out. So I had to go to the Mid-Missouri and do this eviction. And the way that I read the statute was you had to serve it 10 days before the hearing. Well, I did. I showed up and the judge said, "You didn't give proper service." I said, "No, here it is." And he said, "Well, that was only 9 days before the hearing." I said, "No, it's the 15th. We did it on the 5th. Them's 10." And he goes, "No, no, no. It's on or above 10 days, meaning before 10 days before the 10th day." So he goes, "You had to serve it on the 4th for the hearing on the 15th." I was like, "Well, that's not how I read it." He said, "Well, that's how I read it, and I'm the judge." So we had a disagreement in interpretation. Obviously, he had much more leverage over me, so he won. So I had to go reserve, get kicked down the road 2 more weeks, right? So sometimes you see that, and then you see with personal property, we had, sometimes you'll say like all the personal property used on the property is included with the purchase price. Well, what is that? I had a deal right now where the guy said, "I keep a 2020 Chevy Silverado in the shed sometimes, but that doesn't count." Okay, that's specificity. Well, now we have that additional legal provision that helps us better evaluate the financial merits of the deal. Like, oh, if I don't get the truck, in this case, it was a $40 million transaction. Like, we don't need the truck. We weren't even counting on the truck, but this guy wanted the specificity. So ideally, you get a list of all the key property. Maybe you don't say like 37 nails, but if you're going to have a sledgehammer, maybe you write one sledgehammer. Maybe you put DeWalt sledgehammer, whatever the brand is, things like that. So specificity there is key, and then subjectivity and discretion. So give me an example of one you've worked on where you see the first draft and it's got discretion of the opposing party and how that can cause problems.
Yeah, so this might be a different answer than what you're asking, and but it does bring up the point where a lot of agreements will call for a future agreement. They'll kind of say for allocation is a really common one. Either allocating a purchase price among multiple properties, or even among one property or multiple properties, allocation of purchase price to land versus non-land assets, which can have significant tax implications in the case of multiple properties. It can have implications to different limited partners. Sometimes sellers are selling a portfolio of properties where they're the managing partner of each of them, but the limited partners are different. So therefore, the breakdown of the allocation matters a lot to the seller. In the case of land versus not land, it tends to matter more to the buyer than the seller, but that can vary too. And a lot of times for some of these relatively minor issues, you'll see the parties try to have in their agreements, buyer and seller will agree to an allocation prior to closing. Okay, well, it doesn't really call for what happens if
right. What if we don't?
We're unable to reach an agreement, right? And so I always tell clients, never agree to reach a future agreement. If you do, you need to very clearly spell out what happens if you fail to agree. And that way there's lots of different options, but you don't want the seller to be able to say, well, we can't agree, therefore the contract's terminated. Well, wait a minute. No, I mean,
Right.
It's a prime opportunity for ambiguity to pop up, and anytime ambiguity pops up, the risk of a dispute increases.
Yeah, no, that's an example of one where because there's a future agreement with unknown variables, you've empowered the other party with more future leverage because there's some level of their discretion there. So I try to tie it down, not even like reasonable effort or commercial reasonable, or I try to say best faith on things if there are things that you don't know for certain. I just recently executed a PSA for a client did last week, and we don't know if we can get a loan commitment. So we put in there that we will endeavor to get a preliminary loan commitment. But if we don't, then, we're not in default. And we will agree to using commercially reasonable efforts. Obviously, we're going to be trying like heck to get a loan commitment. This is a very complicated, tough deal. Well, seller's attorney put in there that, and earnest money is $100K on this, so a sizable amount. They put in there that if the preliminary loan commitment is not satisfactory to the seller, then the seller can at that time terminate the deal and keep the $100,000 earnest money. I'm like, no way. And so I got back and I said, look, this is on day 120 which is the last day of IP. I said, if by day 120, if we have a preliminary loan commitment and we proceed past day 120, you should by rule be satisfied, because that shows that we are endeavoring to close, and we clearly have faith in it. We can't get a binding loan commitment until like right before closing, typically 3 days before closing, or maybe even at closing by proof of this bank funding the deal. But if we get to day 119 and we do not yet have a preliminary loan commitment, we're going to have really low probability of getting one, and then we're going to terminate the deal. But we can't let you then decide. And this is a case where the seller doesn't really want to sell, but is being forced to due to some court order. It's like, we don't want to give the seller a chance for outs, especially when it's going to cost us $100K. So I see that sometimes where the seller has this discretion, like, or not just seller, buyer, you're going to really limit the other party's subjective discretion.
Yeah, and you'll see it a lot with title review. Generally your contracts kind of discuss title objections and the like, and occasionally you'll see sellers ask for termination rights.
Right.
Where if buyer objects to title, seller has the option to either cure the title or terminate the contract. And that's where we have to step and say, no, it's the other way around. If seller can't cure it, then buyer has the option of continuing with the transaction and the title that seller is willing and able to convey, or buyer has the option to terminate the contract. You don't want to give, just because you say, well, wait a minute, we don't quite like how this exception 32 is written in a title commitment. You don't want seller to be able to terminate the contract and go ahead and sell to the buyer that showed up 2 weeks after you signed it up and accept an offer that's $25,000 more than you did after you've already spent tens of thousands of dollars in due diligence costs.
Exactly. So that's more regular contract provisions as to how to button them up. We see when we get wholesale contracts, they're often really brief and really unprofessional, and we gotta decide, dear client, we think you need to amend this contract, but we can't put the whole kitchen sink in because of the nature of this. So we have to decide what we really care about, how we're going to put it in there, and why we're going to put it in there. So tell me, what are some of the reasons why we typically need a contract amendment?
So, a big one is timeline, because, you'll see a 45, 60-day, inspection period. Well, maybe there's 10 days, 5 days, whatever left in the inspection period, and there's still some pretty major outstanding issues you got to figure out. Well, then the buyer needs to go to the seller and say, look, we're still interested in this property, but we're certainly not willing to commit to our, $200,000 of earnest money become non-refundable. So we're going to need some more time. Well, the seller says, well, why should I give you more time? It's because, well, if you don't, you're leaving me no choice but to terminate a contract. Because again, I'm certainly not going to let $200,000 become non-refundable when I don't know whether I can commit or not. You've got to let me investigate this phase one, investigate, some zoning problems. If the city indicated there's a chance that you're not even legally operating this park, all sorts of issues like that. And more often than not, as long as the seller, kind of understands where you're coming from and you present a reasonable case that, look, I've already spent a lot of money on this. I'm pursuing it in good faith. I just need some more time before I can commit my earnest money to this. More often than not, they're willing to do it. But that's where it's really a really formal amendment. And you certainly don't want to be having that discussion after the inspection period's already ended. You don't want to wait till 5 days after the inspection period, due diligence period, feasibility period, lots of different names for the same thing. And then say, hey, we need more time to figure this out. There's a chance that seller's going to be nice and give it to you, but more often than not, the seller is going to realize that they have all the leverage at that point and say, no, you had 45 days, you had 30 days, whatever, to figure this out. You didn't. You let that deadline go by. Now contractually, your earnest money's hard. Too bad. And either buy it or don't. I'm happy to keep your $200,000 if you want to terminate now. So to avoid that, and it happens more than you'd think.
Oh yeah.
So.
And watching the dates,
by how your listeners would think, at least.
Yeah, and watching the dates is key. So we track them all the time for our clients, but we've got small clients, we've got giant clients that do an equally poor job of monitoring these dates. So watching them is key. And then a business tip here is if you're gonna need an extension, don't wait until the last day to bring it up. That it creates stress for everybody, and it really pisses off the opposing party. So communicate. And another business tip is like when I'm under diligence on a deal and during my inspection period, I'm regularly updating the opposing party. Like, hey, just so you know, got my phase one order. Just so you know, I got a survey order. You may see some surveyors out there. Just giving you a heads up. Hey, I'm scheduling a site visit. Hey, we got loan approval. And that way we're communicating. And then that way, if I do need more time, they're like, well, Bird's been working on it. He's been spending money, spending time. Then I can get a free extension because sometimes I had a deal where I was the seller and the guy wasn't working on it. And I know because in order to have a PCA, property condition assessment, in order to have an appraisal, in order to have a phase one, in order to have a survey, typically they would send somebody on site that my manager would notice, and or they would need me to fill out some questionnaires, especially the PCA. I'm like, I haven't heard from you. I haven't heard from an appraiser. So I know you're not working on it. Well, then they come at the last minute and say, hey, we need more time. I'm like, okay, well, that time's going to cost you. So now I need that earnest money. I need you to put up more earnest money, and it needs to be non-refundable. And if you're not willing to do that, well, then that shows me you're not really serious on the deal. So then just drop the deal. I'll move on. Well, now I have leverage over them because they didn't communicate and or they waited to the last minute. And I had one guy, this group, we were Christian, so we take off Christmas Day. This group I knew they were not Christian. They waited until Friday at 5:30 on the 23rd of December. This is in 21 or 22, to then come back with a massive extension request and retrade that was going to potentially kick us into the next year. And I'm like, I had to get the meeting together with my partners on Saturday morning, the 24th, to see if, and we had supposed to close on the 27th to then see if we can give them more time or not. And it's like, I really pissed me off. And now I got to go tell my family, hey, I'm sorry, I have to work on this over the weekend, or there's $250,000 earnest money up. So it really made me a little more unfriendly in the negotiation. Like, you didn't find out till 5:20 p.m. that you weren't going to have your bank approval 3 days from now. Not buying it, right? So just the lack of communication really hurt them because I was much less willing to be collaborative, and I just told them no, call on your bluff. And they never even responded. They were just jerks. And then on, Monday, which was a Christmas holiday, they said, because it was Monday the 26th, a bank holiday, they said, we're ready to close. If Ferd's not, then he's in default. And I'm like, I am ready to close. All I got to do is sign the closing statement, which is for tomorrow, Tuesday the 27th. But just that level of lack of communication really hurt their odds there. So just more of a business tip than a legal tip.
Absolutely. And along those same lines, I always, some attorneys will disagree on this, but my personal take is the more communication, the better. I mean, there's certainly the legal strategy of trying to play a gotcha, and waiting until some deadline passes and saying, "Oh, look, this is what the contract says." In general, to me, disputes are so expensive that more often than not, it's not worth going that route. And you're better to 3-4 weeks in advance say, hey, just to be clear, we received deliverables on X date. I believe that the inspection period ends at 5 p.m. local time on this date. Are we on the same page there? And occasionally you'll say, no, I thought it would be this. And you can usually work it out. It's like a day or I've never seen a huge dispute when they have that conversation.
Right. Early, when it's early on, it's like, look, it's either 39 days from now or 40 days from now, but getting rid of that that vagueness and creating a mutual agreement. That's a good point, especially on one where there's a floating timeline. Sometimes it's easy. The inspection period ends on the 10th of February. Okay, that's easy. But if it ends 30 days from receipt of the last deliverable, but what if you get the deliverable list, but like it was a little unclear, if everything was technically compliant, and that's a good point. I mean, and just really figuring out what the dates are. And then another reason I see for us to change dates or change contractual terms is upon receipt of new information. I thought I was going to get 22 mobile homes with this purchase, but upon inspection and your records, you only have title to 19 and 3 are abandoned. That's a misrepresentation, perhaps accidentally or ignorantly. but that's a material change of the assets. So I'm going to bring it up that I would like to modify the agreement to say I only get 19, but I get, a quick claim or a bill of sale on the other three. But because you don't have good title, I also need a price concession and, retrading price. I have a whole nother episode on that. That's how to do that. But that's another reason for a contract amendment, is modification of price or modification of property to be transferred. And even more so than timelines, that is something you don't want to drop on their door, at 3 o'clock on the last day of IP, because I've seen guys, I've seen that where we do it 2 days in advance and then the guy doesn't respond. You
Yeah.
check in the next day, the guy doesn't respond. And I know what's happening. He's hoping we let that 5 o'clock. We try to reach him. If we don't, we make sure to get the notice out before 5 o'clock, if that's what the contract says. If the contract says by email, by the way, and not by the mail delivery, by email, return receipt requested, delivery receipt, read receipt, and it says, "Dear Doug, I haven't heard from you in 2 days. Please consider this notice of termination of the contract. If you'd like to reinstate the contract in conjunction with the amendment I proposed, open to that discussion." But I see guys all the time mess up on that kind of stuff, and it's super stressful for us because we know the ramifications. And it's the clients sometimes are like, "No, he's good to go." We were talking about one this morning. The guy's been out of contract for 6 weeks. "Oh, don't worry about it. Seller's still working with me." Like, he is until he gets a better offer.
Yeah. And one kind of addition I'd throw out there is, first of all, I completely agree with you, and this happens all the time, is that, you have, 24 hours left in the inspection period and you're still, come to negotiations about an amendment. You don't want to leave a dispute about whether there's an agreement. So, I mean, sellers will do that, and buyers, no need to panic. You just calmly terminate and say, we're happy to reinstate via a simple amendment, but you want to protect your earnest money first and foremost. But the caveat to that, I would say, is if you're a seller of a park, I don't think it's necessary. I mean, sellers do this all the time. And I don't think it's necessarily best practice for sellers to go dark in the middle of negotiations with the deadline approaching, just because it's also a recipe for a dispute. Because, even as a buyer's attorney, we would say best practice, be very careful about these deadlines, or on the side of caution, and make sure you terminate before there's any argument whatsoever that your earnest money is non-refundable. However, if you're the seller, that doesn't mean that it's best practice just to disappear on a buyer as a deadline's approaching, just because you don't want the buyer to turn around and say, "No, look at this email chain, XYZ, we had an agreement in principle." Then the buyer's mad at you. If you're trying to sell your park, the buyer might think, this guy's operating in bad faith. I don't want to buy from him anymore. Now, all of a sudden, instead of, getting a purchase price that you're originally happy enough with to sign the contract, now all of a sudden you're paying potentially tens of thousands of dollars in attorney's fees, to fight a pretty expensive legal battle over was there an agreement to extend the inspection period or not. So in general, I almost always recommend to clients just communicate. If this is your interpretation of something, be upfront about it. Not only is it legal best practice, it's best business practice. You'll get a better reputation, and people are going to want to do repeat business with you, say good things about you to other people.
Yeah, good point. And I think another thing that I thought of when you were talking there were things that we didn't know was going to be relevant that is now relevant. Like sometimes the client will not tell us that they have a handshake deal with the opposing, like the seller, that are going to take over the seller's loan. So like we just put in there like we're going to buy the park, and then we find out, oh, there's a Fannie Mae loan assumption. Okay, well obviously the parties are going to work together on that, but then they didn't talk about, and we didn't know that they were going to do this. They didn't talk about who's going to pay the fee, because there's a 1% fee. Our template contract would probably say that buyer would pay loan fees, but seller would pay any prepayment penalties. Well, what if there's a loan assumption versus a loan payoff? Which is it? And is there a minimum maximum on, there's a fee, defeasance fee versus yield maintenance fee versus transfer, and there's minimums and greater thans in there. So I think just anytime there's something that you're aware could be contentious, like why not figure that out earlier on before you're potentially losing on that provision?
Exactly. And I think that speaks to the broader point of never rely on a third party, whether it be a lender, a city zoning department, anything like that. never rely on a third party to perform after your own deadline is passed. We keep talking about the inspection period, but that's the most common example of that. Is if you're identifying a potential issue, well, wait a minute, we're still waiting on the zoning letter, or we're still waiting on Fannie Mae to approve this loan assumption. We're pretty confident it's going to happen. Let's just not worry about it. Well, let's say a week after the inspection period, you learn there's a deal killer. Either like a lender's not going to perform, they're not going to consent to a loan assumption, the city's not going to sign off on your park zoning. Now all of a sudden you've got a dispute over your earnest money again. So that's where it's just important to identify these potential disputes before they happen and address them by amendment.
Yeah, good stuff. All right, Doug, we've covered a lot. Anything else come to mind? Last tips or tricks or anything before we go?
I think the main thing I'd say is, everyone is cost conscious. I spent 4 years as a client and as an attorney, so I'm sympathetic to that. But to me, avoiding getting an attorney involved, again, a lot of people think that when you hire an attorney, you're paying them to write some 30-page agreement that really should be a 2-page agreement, or you're immediately going to sue somebody because you hired a lawyer. In general, you're going to be dollars ahead by far to bring in an attorney into the loop relatively early on. As soon as you realize there's a potential of a dispute, maybe your attorney's going to realize that it's been a potential dispute in a way that you will not, as a non-attorney, and basically paying for a couple hours of their time can easily save you tens of thousands of dollars in costs if you let the dispute kick it down the road until it becomes a much bigger problem.
No, that's a good point. Reminds me of a story when I hired a consultant. I was a county appraiser in Jackson County, and I hired a consultant. He gave me this story. The guy also coached pool. He was a professional pool player and coach as a hobby. At this point, it was a consulting hobby. And he said, here's what happens with a lot of my pool clients is they'll have this really hard shot. They'll take the shot, they'll make the ball, but it'll roll back around, and then it'll end up getting them in a position where they're behind the 8 ball. And they'll call timeout, and they say, Jerry, I need your advice. What do I do? And he says, you should have asked me that one shot ago. At this point, it's too late. You've put yourself in a spot. I can't give you enough counsel. And that's kind of the same thing. Like an ounce of prevention is better than a pound of cure. Later. So obviously it's self-serving a little bit as lawyers, but it's like, no, we got enough to keep us busy. We're not trying to manufacture work. We're trying to avoid disputes, because ultimately that's going to help us win more cases and win more matters and have better overall client satisfaction and results. So good points, well taken. Doug, appreciate your time today. For those that want to reach out to Doug, MHP Law Firm, you can find his page on there and his practice areas, and reach out to us, get an email going, and happy to chat more. Look forward to the next time. Thanks again, Doug.
Thank you.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.